Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. This series is designed for my students to give them a little bit of a review, but it is designed for all of us to learn more about the Constitution. This semester, I am posting short videos, short I hope, on various concepts from First Amendment law that we are discussing in class. We've been talking about, well, before I get started, our court interpretations here are my own and are not to be ascribed to my school or my students. For informational purposes, I've been a professor for about 30 years now, teaching law and business courses. I'm currently a professor at Mississippi College School of Law. Let's get right to it. In First Amendment, we have been studying unprotected speech, the general rule being that government may not regulate the content of pure speech unless it satisfies the highest level of scrutiny or unless the speech is in an unprotected category. As this is a short, I will not review all of the other categories we have covered, but I have a link at the bottom where you can take a listen if you like to hear more about other topics, other types or categories of unprotected speech. Okay, so the category we're going to talk about today is obscenity. Obscenity is a category of speech that government may regulate more freely as it is considered to be unprotected speech. I want to reiterate something here that one of the judges I worked for told me. We were working on a case involving obscenity, and he said, Angela, an opinion on obscenity does not have to be obscene. So here, although I'm going to be summarizing about the law as related to obscenity, I assure you it will not be obscene. Now, the court, so how do we decide if speech or message is obscene or not? The court has struggled greatly with how do you define the category called obscenity. One justice even made a quote. He said something. He said, I may not be able to describe it, but I assure you, I know it when I see it. That's what Justice Stewart said. But in a case called Miller versus California, and I've put a summary in the text box below, the court did attempt to describe or define this category of unprotected speech. So we may all have our individual views as to whether something is obscene or not. But the court said for the speech to be considered legally obscene, then it must satisfy a three-pronged test. Remember, if it is obscene, government may regulate it more with a low-level, rational basis level of review. So first, the court says you look at whether the average person applying contemporary community standards would find that the work as a whole appeals to prurient interests. Now, that's a lot. There are a lot of different components of the first part of the test. First of all, the court says you look at the average person. You do not look at the most modest person, and you don't look at maybe the, I don't know, the wildest person, but whether the average person applying contemporary community standards. One of my students was pointing out that the community standards may change over time in terms of what is considered to be appropriate or not. would find that the work taken as a whole. So for example, you may have a book and one passage of the book may have some very steamy kind of scenes that by themselves may be considered to be obscene. But the court says you look at the work taken as a whole and whether it appeals to the prurient interest in sex. In one opinion, the court tried to distinguish between what is considered to be a normal, healthy interest in sex versus what is considered to be a prurient interest or a debased interest in sex. So that's all of that is the first part of the test. The second part is whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. Now, in Miller versus California, and you can Google the test, the court did give some specific, some people may say graphic, details in terms of the kinds of things that the court, that the state may describe in state law as being patently offensive. I won't go through those here. I'll leave it to you to Google the case and read that for yourself. The third part is, even if you satisfy parts 1 and parts 2, the third part of the test must be met. The third part is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So for example, you may have a biology textbook that has some fairly graphic pictures that some people would say meet 1 and 2, but it would meet part 3 because it may have serious scientific value. You may have a song that may meet, or a recording that may meet parts 1 and 2 of the test, but it may have some serious literary value. If so, then it would not be considered to be obscene under the Miller test. Now, in evaluating obscenity, as you can imagine, the court runs into a number of difficulties. Number one, the court is having a hard time just describing what does it mean for something to be obscene. So the terms that the state uses in its law may be vague, it may be unclear, or the state may have a law that's substantially overbroad. It may cover too much speech that is also protected. And so that creates a problem in terms of evaluating the law on obscenity. And in the text box below, I referred you to another video clip that discusses vagueness and substantial overbreadth as problems in evaluating the law. Now, another thing is the court said, okay, so if the speech is obscene, government may regulate its content more freely. But then the court says there is some speech that may not be obscene under the Miller test, but it may be nearly obscene. Say what? The court says there is some speech that may not satisfy the Miller test for obscenity, but it may not be the kind of speech that we send our sons and daughters off marching to war to defend. So the court has crafted some content neutral, reasonable time and manner types of, that certain content neutral, reasonable time and manner regulations may be acceptable. And in addition, the court says that it may not be content neutral. So for example, a law that says nude dancing, that the dancers must wear at least a G-string or pasties, Some will say that's not content neutral. That is being applied specifically to a certain type of speech or expression. But the court says, well, you're kind of right. However, in that setting, maybe the state is more concerned with the secondary effects of the speech, for example, related to crime or what have you. So the court has regulated that speech more to allow for certain restrictions on adult theaters, for the location and what have you, and also certain restrictions, for example, for nude dancers. They cannot be, the state can restrict them from being completely nude. But I have a link at the bottom to a video clip where I explain more of those cases. So you take a listen. You know, the topic of obscenity gives the court a great deal of pause and hesitation. But here in this short, I've attempted to give you the Miller test and also to tell you a little bit about some of the problems the court runs into for speech that may not be obscene under Miller, but that the court does want to allow the government to regulate itself. So take a look at those clips I've indicated below. You know, learning is just so amazing, isn't it? Learning can lead us to enlightenment, and enlightenment to freedom, and freedom to justice. And my goal here is to give you at least a taste of justice. So I'll see you in about a week. And the next category I will tell you about is I would do a short on fighting words, the fourth category of unprotected speech. Okay, you take care. See you next time.